This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about why a hero, even if that's his true name, cannot convince the court to change a policy to what he needs, and that an attempt to make a CGL policy into a course of construction policy will always and should always fail. On December 6, 2017, a fire destroyed the residence in Belle Chasse, Louisiana. The residence was under construction but substantially completed at the time. In a case entitled In Numa C Hero LLP, through its general partner George Allen Hero, versus Brit Underwriters Limited and Erwin Insurance Agency, the Court of Appeals of Louisiana on December 21, 2022, resolved Hero's claim for the destruction of the property because it was not described on the policy declarations page. The property was owned by In Numa C Hero and Son LLP through its general partner George Allen Hero. Hero was constructing the residence on the above-mentioned property, which upon completion was to be purchased by his daughter and son-in-law, Victoria and John Dillman. Through its agent, the Erwin Insurance Company, Inc., Hero had obtained an insurance policy called the 4S policy, covering a number of properties it owned from certain underwriters at Lloyd's, London, primarily Brit UW Limited, hereafter collectively referred to as defendants, or Brit UW. The policy provided general liability and certain property damage coverage. It contained a commercial general liability coverage form, a building and personal property coverage form, and separate declarations for each type of coverage. The policy's declarations are separate and distinct for commercial property coverage and commercial general liability coverage. The insuring agreement makes clear, with respect to property damage coverage, only covered property that is described in the commercial property coverage part, and for which a limit of insurance is shown in the declarations for that type of property. Only they are covered. The property coverage declarations describe, however, no premises, building, or structure in Belle Chasse or Plaquemines Parish, including the subject property, the one that caught fire. On June 4, 2018, Hero sued for damages for breach of contract and alternatively for malpractice against Brit UW and Erwin, claiming property damage by fire at the Planters Canal Road dwelling. Hero contended that the house then under construction was covered by the 4S policy, and if the policy did not provide coverage, its insurance agent Erwin was liable for malpractice for failing to secure such insurance coverage. Although previous attempts at summary judgment failed, the defendants were successful in their fourth attempt. They contended that there was no commercial property coverage under the 4S policy for Hero's claim for fire damages sustained to the building under construction. In their motion for summary judgment, the defendants were able to make a prima facie case that there was no property damage coverage under the 4S policy for the structure that was destroyed by fire because it simply was not listed. The summary judgment procedure in Louisiana is designed to secure the just, speedy, and inexpensive determination of every action. The burden is on the adverse party to produce factual support sufficient to establish the existence of a genuine issue of material fact, or that the mover is not entitled to judgment as a matter of law. A prior denial of a summary judgment does not preclude the granting of a similar or even the same motion later in the same case. In my personal experience, I once had a case where a motion for summary judgment was denied, and after 3 years of litigation, it was resubmitted to the same judge. And the defendant argued that he had ruled in his favor 3 years before, and it's the same motion, only to have the trial judge respond, well, I was wrong 3 years ago. And the Court of Appeal eventually affirmed that statement. The party seeking insurance coverage bears the burden not only of proving a relevant existing policy, but also coverage under that policy. The insuring agreement in the building and personal property form provides that the declarations section, because the lot designation for 431 Planters Canal Road listed as location 44 is not referenced in the description of premises or the coverages provided sections, there is no indication of any building on that lot. There is no limit of insurance shown for that property or structure, and there is no premium charged for coverage. Based on the fact that the property declarations, when compared with the property coverage insuring agreement, it became clear to the Court of Appeal that commercial property coverage was not afforded for any structure located on Planters Canal Road. Accordingly, Hero failed to meet its burden to prove that the property coverage existed for the structure under any policy, including the 4S policy issued by the defendants. Although Hero responded to the motion for summary judgment, he did not attach any evidence to show that the defendants were not entitled to summary judgment. Argument of counsel, which includes memoranda supported in support of or in opposition to a motion for summary judgment, is not evidence, no matter how artful and persuasive. Likewise, argument of counsel and briefs, no matter how artful, are not sufficient to raise a genuine issue of material fact sufficient to defeat a motion for summary judgment. Further, an opponent to a motion for summary judgment must attach evidence demonstrating a dispute in material issues of fact to its opposition and cannot merely incorporate by reference exhibits previously attached to other legal documents. Accordingly, Hero failed to meet its evidentiary burden in opposition to the defendant's motion for summary judgment. Evidence such as affidavits and deposition testimony are permissible to determine whether an insurance policy is in force or where there is a factual issue as to the applicability of a provision of a policy. Also, the trial court's consideration of evidence in support of a motion for summary judgment is an evidentiary ruling, which is subject to the abuse of discretion standard of review. The deposition testimony and affidavits offered in support of the defendant's motion were offered to show that no policy was in effect for the residence under construction, and that neither Hero nor its agents ever requested such coverage. Hero's argument that it expected or believed that it had insurance coverage does not support a finding of ambiguity, nor is it evidence that coverage was ordered or obtained. Insurance coverage is determined from the written instrument, not the party's expectations. That Hero may not have known that another type of policy was required does not mean there is coverage under this policy. It only supports an action against Hero's broker. As such, there is no ambiguity in the insurance contract. All of the issues raised in this appeal were also raised by Hero in its motion for new trial. Hero asked the court to take a different view of the factual evidence, the deposition testimony, and its reading of the policy than that taken by the trial court. Hero did not demonstrate that the trial court abused its discretion in any way. Accordingly, the Court of Appeal concluded that there was no abuse of discretion in the court's refusing to grant Hero a new trial, and the trial court's judgment granting a summary judgment in favor of Brit UW defendants and against the Hero plaintiffs was affirmed. In my opinion, a court will not change an orange into an apple by judicial fiat, nor will it change a policy covering the insured's liability to third persons into a course of construction policy. If such a policy was ordered, Hero may have a case against the agent. If not, the Hero plaintiffs receive the coverage they ordered, and the case of the agent will be difficult to prove unless they can show that the agent accepted a fiduciary relationship promising to buy all the coverages Hero needed. If they did not, this case will eventually go away and Hero will get nothing. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. If you wish to continue receiving these blog postings, simply hit the subscribe button and you will be advised of every blog posting, approximately 5, sometimes more a week, where we already have more than 4,400 blog postings. You can also subscribe to the videos on YouTube and rumble.com. Receive notice of the more than 500 videos presently available. If you found this video and the blog posting to be useful or interesting to you and your colleagues, please let them know so that they can also subscribe to the videos and to the blog. Thank you for your attention.